So it's not about a form, it's not about a workflow, it's not about one little tick box exercise. It's about thinking about the whole of the law firm's technology, what they're going to need in 5 years' time, and how we bring that together for us in the market when we're looking at risk across that practice.
Some of the major design principles that we had have really stood us in good stead from the outset. Law firms are very slow to change technologies. They're very reluctant to manage change a lot of the time, and for good reason. You know, they're fee earners. The RegTech part and the AML burden on them is huge.
Does it go over our insurance limit in terms of how much it is? So I think there's all these things that actually are all done in isolation.
They might not understand that what proliferation financing is, or what a high-risk jurisdiction means for that type of work that they're doing. And yes, we will coach them so far, but we're really passionate around working together with the compliance community as well.
For what we do, any mistake we make, you know, whether it's advice, whether it's compliance, you know, our whole career is on the line all the time.
Yeah. Is there a proliferation financing risk? And I was like, do your staff know what proliferation financing is? And they were like, no, we just had to put it in there because obviously the regulations changed. And we had to put it in there. And I'm like, I'm pretty sure no one knows what that means.
Thank you so much for joining us. Hi, ladies. Hi, Kaylee, Jane, Kate, Amy. How are you?
Good afternoon. Really good.
Afternoon.
Calling in from Sheffield today. In the rain, in what appears like biblical rain here. I don't know what it's like everywhere else.
Where's the rest of you based from?
I'm in Essex, and it is pouring and it hasn't stopped all morning.
Nightmare.
I'm Bristol. It's actually quite nice outside. Sorry, guys.
It's not so nice in Yarmouth. Very rainy.
Well, I think the sun always shines on the righteous, Kaylee. That's our problem for the rest of us. You've got that in Bristol.
Well, thank you all for joining us, and thank you for everybody who registered. Today, we're hosting a webinar in collaboration with Foresight. My name is Arslan from Aventine Lab. I'll let everybody in the room to introduce themselves. We have a great guest panelist here, but essentially today is all about providing practical guidance for law firms on all things risk assessment, from matter, firm-wide, and client. And we have subject matter experts of all levels, from lawyers as well as compliance consultants and product development experts. We're covering 3 main themes, and again, we'll just dive right into them. The first theme is the SRA template. Is it adequate? How useful is it? And the second point is it's not all about AML necessarily. And the third point is the enhanced due diligence trap. So we'll go through all of them, but before we do, let's get off with the introduction. So Jane, why don't I pass it to you, and then you can pass the mic to the next person. And yeah, let's get this.
Thanks, Arslan. Hi, my name is Jane Pritchard. I have had the role as a practicing lawyer, a partner in a law firm. I've been a consultant in digital transformation, and I've been more recently, over the last maybe 10 years, in the dark side of actually developing the software, the tech side of the business. So solving those problems with technology. So that's me.
Hi, I'm Kaylee, Kaylee Smale. I am head of compliance at Foresight, but also run my own business, Smale Compliance. Self-confessed AML geek. You'll see my I Love AML badge comes with me everywhere. And I just want to help law firms get it right, really. So Amy.
Hello, I'm Amy. I'm managing partner at Lucas and Willis. We are a fairly small practice over on the Norfolk coast. 3 offices, 28 staff, covering private client, family and conveyancing. And I'm here today with my hats of MLRO and head of conveyancing to give more of a practical, hands-on approach.
Hi, I'm Kate, and I'm a member of our professional standards team across 6 law firms that now sit under the banner of the Lawfront Group.
Great. So that's all of us.
Yeah, sorry for that. There was a little delay in getting back to the camera. So Jane, you wanted to talk about the SRA template. You believe that the firms are being actually let down. There was a huge study and a publication came out by the SRA saying actually the problem with the firm-wide templates and all these templates is that it's not tailored. And you were talking about that. So why don't we start with that and give us some idea on what you think on that?
Yeah, so the challenge for me, I've been looking at firm-wide risk assessments, client and matter risk assessments for some time. And I've seen hundreds of different client and matter risk assessments. And specifically with Foresight, over the past 12 months, what I've been seeing is firms really struggling with the fact that their foundation somewhere in there is this 7-page template that the SRA has provided and said, don't use a template, but by the way, here is a template. And here is our best job at telling you how you could potentially assess risk on essentially a paper form. So the SRA's template, I think, is a challenge because law firms are really struggling with, well, if our regulator says that this is a good, assuming it's good because it's got their brand on it, template for us to understand how we could assess risk at a client and matter level, specifically, of course, for our AML risk, why would we not use it? And how can we not use it? And how do we then potentially, for our practice, just add bits on top? So we sometimes talk about Frankenstein tech, but actually the risk assessment from the SRA, the template, is like a Frankenstein template for client and matter risk assessment, because it isn't really, that's the challenge there that I would say is what law firms are struggling with. I think we'll go into more details specifically on it, but I would maybe ask Kaylee as well. I know we've picked out 3 particular areas, Arsalan, on the SRA template, for that we've picked out some questions to give some examples. I think Kaylee can give us some examples of those, and then maybe Amy and Kate as well on these particular 3 and how these are directly from the SRA's template and how you would manage those risks in your practice. Kaylee?
Yeah, I think I'm going to go in the middle. I'm going to go for proliferation financing, because I think that's one of my favourites that I see in at the moment is this question is, does the matter involve the risk of proliferation financing? I was doing some file reviewing the other week, and actually it was a company that it was a chemical company. They packaged and distributed chemicals. Chemical was actually in the name of the company as well. And when it came to that section on does the matter involve a risk of proliferation financing, they put no. And for me, I was like, I don't think staff understand what proliferation financing is. So have you given any training? Have you told them about this? Have you explained what this is? And they were like, well, it was on the SRA risk assessment, so we put it in there. Everyone had this like mad rush of going off and putting all of these questions in without really understanding or giving staff like the background of what it actually means. So the proliferation financing one, and it is a tricky one. Don't get me wrong, it is so tricky. But without any further guidance, then they're not really going to understand what that means and whether they should be ticking yes or no to that answer.
Yeah, I agree. And Amy, what would you say? What was your of those 3, which is the one that maybe you think from an SRA's perspective needs more interpretation for lawyers who are actually doing the assessment to adopt?
Yeah, perhaps the delivery channel risk. We've come through COVID, things have changed. We don't see many clients face to face nowadays. The guidance is just it's very plain. There's not a lot there to go on. What about this option? What about not, electronic checks? Have you done that? Are you seeing him in person to verify their ID? Just key messages of simple things you can do, because it's difficult enough as it is. If they could expand upon it and give you some practical tips of ID, for example, checking the ID properly. You're seeing them in person. Are these ID checks approved by the SRA? Are they happy for us to do these different checks? It's just all very woolly, difficult to interpret.
I imagine, Kate, for you as well, because you've got multiple brands under the law front banner, and what delivery channel risk means to one firm might be different to another, depending on how they practice, what they practice, where their clients are spread geographically. So what does that mean for you guys? How do you manage that?
I think over time it's become easier, if I'm honest, because we've started aligning lots of AML, because that is the only way forward for us. We'll all be working on one case management system soon. We'll all have the same CMRA. So we're all using the same onboarding. We've got a centralized team. We've all been trained what to watch out for. But you're right. Who meets a client in person these days?
And
it doesn't really happen.
And also, like, the question on the actual SRA's risk assessment says, if no, how are we satisfied the client is who they say they are? And so, like, what would you write? I mean, I'm not, and that's a rhetorical question, because I'm satisfied because, so if you left it down to your staff, to fill that in, or your analyst to fill that in, I mean, that would mean something different to somebody else, unless there was something driving the context behind that and joining, like you said, Amy, all the different bits of identity, etc., bureau checks, all that piece that comes together. If you just, the question itself is so open, isn't it?
Yeah, it is.
What about complexity of transaction? I mean, this is like one of my favorites, because when I was practicing law, understanding the complexity of transaction, for example, if it was unusually large or complex, it varies so much. And this box is just saying, is the transaction unusually complex or large? And I don't know what's in Amy's head, Amy, for you to be able to answer that question, if you were doing this, or if somebody, Kate, in one of your different offices understood what complex means. I don't know, Kaylee, do you find that when you're on trials?
Yeah, I think the complex part, I normally get people saying things like, well, due to the nature of the work that we're doing, it is complex. And I think, no, that's not what we're trying to get at. We're trying to say, is it unusually complex? And it's the same with the unusually large as well. How would anyone know what's unusually large if they don't know what everyone else in the firm is doing? So one of the things that I've been trying to do with firms is actually saying to them, each department, what would be unusually large for you? What's your average, sort of size? And then anything above that, then probably you do want to speak to, the compliance team about. And it's not something they'd really thought about before. I think normally they tag it in with their PII. Sometimes they might say anything above this amount, because obviously that's all we're insured for. But it's actually thinking about, and then they have the issue that some people having to have to go to compliance all the time. Because actually the nature of the work that they do is it does go a bit higher. So it's just making sure that they understand, the unusually complex part of it and the unusually large part of it, rather than just complex or large. And I think it's really cruel to have fee earners try to figure that out themselves.
I like the idea of that being cruel. It's brutal to say to the end person, interpret it, because they're the ones who have to get it right. Amy, I know we've talked about this before, anecdotally, but like, you don't use the SRA's template, and you chose not to.
No.
And part of that is, I'm assuming, because you looked at this and was like, how am I supposed to roll this out across my practice, or how do I evolve it?
Yeah.
What was your approach to that? What did you do instead?
We actually use the Law Society Scotland template for our risk assessments, and we have done, and we've adapted that over the years. And when you look at that, 7-page document, I think it is the SRA one, lots of, like you say, they say don't use a template, don't make it a tick box exercise. It is a template. It has got lots of different tick boxes on it. And it doesn't really round up the information. The template we like to use, it asks more questions rather than, think about this, have you thought about that, what about this, so you can give more of a rounded approach. It's absolutely fine what we do. We had the SRA desk-based review last year, no issues whatsoever. They didn't come back and say you're not using our template, why aren't you using our template? So
a really good point. Yeah,
it's fine. Yeah.
And Kate, for you, what's your approach to that? How do you, obviously you spend a lot of time looking at this, how do you interpret how to use it, or which bits of it, how do you evolve what that looks like for your client and matter risk assessment?
We did start off with the SRA template. We used that as our basis, and then we had to adapt it to take account of 6 different firms and what they wanted on it, and without turning it into what would then become a 14-page tick box document, we sort of grouped some questions together and reworded them in the hope that it would make more sense and was more applicable. And we're going through the testing phase of that right now.
And one of the things, looks like. And one of the things that I've done on the transformation side is looking at all the different risk assessments. For example, you'll have one part in the SRA's template to talk about source of wealth and source of funds, and it's not really getting to the bottom of whether that matches the person's financial profile. So when I'm looking at this from a product perspective, I'm looking at what is the actual flag of risk? How can I identify that? And therefore, rather than asking an open question that is basically a leading question that is guiding you to a yes or a no, that it is an assessment that is guiding you through a conclusion that is actually based on the information in front of you. And I think that is a good example would be, There's some really straightforward examples of like when you're thinking about PEPs, are they domestic or non-domestic? It's not just are they a PEP, yes or no. Let me get out of this PEP assessment quickly. It's not relevant to my client. Get it out. How do you know it's not your client? Like, is it domestic or is it non-domestic if you do go through that process? But also like on other areas of that, when you're thinking about things for AML, source of funds, how you know what you know. It isn't just simply, are you satisfied with source of funds? It's why and how, and does that make sense? We come back to all the time when Kaylee's working with me on the product side of risk assessments, like how can we ensure that the question that you ask in a risk assessment is open-ended sufficiently to understand, does this make sense? And a good example of that would be the confidence level. If you've got lots of data on biometrics and NFC and safe harbor and bureau checks, how do you assess confidence in that if you have to work that out on the back of a on the back of a stamp, if you have to write it out and think about it yourself? So I think that's my side.
Yeah, I think it's I think law firms I think fee earners really need help guiding them through the process, guiding them through that thought process, and just having questions that, like you said, is the transaction unusually large or complex? Well, yes. What do I do if it is yes? Because there's not really anything that tells you what you need to do then. So I think it's just making sure that you have that guide in it and explain to them, these are high risk factors, and if these do come up, then you do want to be speaking to someone else about it. I think that's the problem. It's just I think sometimes in the end as well, and it's not the fee earner's fault, they end up just knowing the boxes to tick to be able to just to get them through, because yeah, and they just tick the boxes just to get themselves through the form, because they don't want it to show as high risk for whatever reason. I was doing file reviews again, and there was a risk assessment, and it had some conditional logic in there, and if they selected that it was they had to select what the work type was, whether it was high, low or medium, and they had like a form that told them what work type was each. And commercial property were saying that all of that they weren't in a high risk sector. They didn't have a high risk work type, which meant all of their risk assessments were coming out as low risk. And I just said, I don't know whether that's being done on purpose, because every single one of them I checked, the same thing had happened. I don't know if it's because of that, or if it's because they want to make sure that it isn't high risk, so they don't have to go and ask more information.
Get that matter opened.
Exactly that.
Then they can start the transaction. Yeah. I was
going to ask a question, if that's okay, just on that basis. The completing the CMRA, because it's something we're in debate over, whether or not it has to be completed in full before a file is opened. Now, we're going with a 10-day prior to anything substantial happening window for them to complete it, because by then they'll have more information, can make more informed decisions, rather than, as you say, doing the tick box to get the file open.
And I think, Kaylee, if we come on to the next slide as well, and we talk about the non-linear process for risk assessment and the different types of risk. So when we're looking at the next piece in our conversation now, that's a really good entry, Kate, for us to say, like, what does it mean? Because not everything you do in the transaction is related to AML risk. Some of it is regulated, some of it is matter risk. And my view is, you as a practice should decide how much of that is completed. And there was always, when I was a partner in a law firm, there was always this binary motion. And the reason we have this is because lots of law firms, whether you were dealing with it in a paper way or in an entirely digital onboarding way, always said, do all of that before you can open your matter, or you can open your matter and do it. There was like one way or the other. There was no kind of, because what is it? Is it everything to do with your client risk, your jurisdiction risk, is, sanctions, right at the top, right? So the order in which you do that, and when you know enough about your matter risk, Kate, to start, and then if that means it's not a one-time risk assessment and you can come back and reassess your matter risk, then you're reducing the risk because you're doing everything as you can, what you need to do proportionately at the beginning. You can tell I'm very passionate about deconstructing your risk assessment to make sure it isn't all front loaded and then you never come back to it. because that way lawyers will always, anyone in that process will always fight that. And they'll always do as little as possible to get through it without looking at the full risk. I'm going to hand over to you, Kaylee. I know you wanted to say something about that, I could tell, and I was,
Yeah.
sorry.
That's all right. I think it's really difficult to just have a risk assessment that's done at the start, because like you said, that you're not always going to have all the information at the start. So I think it's really important to make sure that there's a process for the fee earners to go back to the risk assessment and keep adding to it and amend it. It's like it is a living, breathing document throughout the course of the matter, because so many things can happen and so many things can change. I think it's really great to have controls in place to make people stop and think, whether or not it is that 10 days where you say, right, we're going to stop the matter unless you have this information, or whether it's something in your workflow that says you can't proceed until you've re-looked at the risk assessment. But it's really important to have that. And under the money laundering regulations, you do need to conduct ongoing monitoring throughout the course of a matter, just not your client. I see if client ID is great, people have got that nailed now. They're doing their ongoing monitoring for that, but the ongoing monitoring of the matter itself is still really tricky for lawyers to be able to do, and it's really important that you do it. So having that time to just make some like triggers in place to make people stop and rethink and reassess, asking someone about source of funds at the start of the matter when they've only just met the client and they haven't even opened their matter up, it's going to be really tricky for them to answer. And again, they'll get to that point where they are just doing that tick box. I mean, I see all the time own funds, on forms where, the source of funds, it just says own funds, because they feel like they've just had to put something down to get that pushed forward. And that doesn't help anyone. So having those controls in place to try and, force people to say, you need to think about this. And I think, a lot of firms do put that, we're going to stop your matter because you haven't got this yet. And it's a really good way of making people stop and think.
Except it might drive the behaviour of like putting rubbish in order to get through. But yeah, you're right. Amy, what's your view on that? And I'll tell you, a client asked me recently, I'll tell them what I said to them.
We have to open our file to be able to send them the checks that we need to get the information to do the proper risk assessment. So we do open it. We'll take it, perhaps on a sale purchase. If we've had agents' details in, we will do initial letters. But that's kind of as far as we'll go, and we'll be saying to clients, look, we really need you to fill the rest of this information in now so we can complete our risk assessment before we can go to the next step, because otherwise, if you get too far down the line, they just think you're just going to keep going. So you've just got to keep proportionate. But you're right, I don't think you could put a blanket stop. If someone came to me and said, oh, I really need to get searches on this one because of X, Y, and Z, then great, go ahead and do that part, but just make sure you've got diary notes and you are reviewing make sure the clients are filling out everything they need to fill out to do that next step.
I think one of the challenges is that people have put workflows in that are really linear, and then if you have a workflow for every type of your practice and it says we do these 3 things and then you can start, it's too much of a straitjacket. So when we were approaching this from Foresight, and when I had a client ask me this week, because we've literally deconstructed it, so it means that you can choose based on the type of matter that you've got how this works. You might want to start with a client, Kate, who has just got their identity and you're waiting for that, and your identity provider that you use might also give you your sanctions and your PEPs results. So you can't really do a lot on that, but your fee earner, your lawyer, or your analyst could be doing the matter risk assessment while they're waiting for that. So for me, like the absolute top level sanctions and PEPs, one of the challenges is, and it's a pandemic challenge, is there's loads of fantastic tools in the market that do identity, but they tend to wrap everything up in one. And actually, you want to know they're not a sanctioned and they're not a PEP, and then happily go on and monitor that. But your identity, for example, that might be a bit of friction in the process. So you might want to run their identity and then decide that you could manage or make reasonable adjustments for that and move on. So it just really depends on you as a practice and the type of matter it is. And that's really important. And the type of client it is. Is it a business client or is it an individual client? So this really is pulling that apart and saying you could actually make some choices which are not binary. It's not all or nothing now. PEPs and sanctions, if you do anything before you've done that, we're all going to be in trouble. The Tower of London beckons. But if you are, and if you're waiting for that, that might be justified for you in your practice for identity. But if this is a case which is simplified due diligence, and your policy says that you just something much lower for that. Why are you not starting work? And what does that bar look like for you?
That's
So
a
two
really
things
good
from me.
point.
Sorry, Kaylee. One quick thing. Chat. If you guys are watching, let us know you're watching. Press 1 in the chat so I can know you're here, you're watching. And please ask Jane question and answer some of these questions that you're seeing live on the screen. And we'll dedicate a portion of our time at the end to answer chat questions. So yes, please leave questions for us, and Jane and the team here will answer.
Or give us comments about what you've
Yeah.
got. Like, it doesn't have to be a question. You can say I agree or I disagree or whatever. Kaylee, sorry, go on.
No, that's okay. So I just think that point on, having kind of the same process for absolutely everyone. I think when the money laundering regulations changed in 2017 and they had to have, you had to do client due diligence, you had to have risk assessments. I think people kind of went for that whole firm approach, which, at the time was a really good idea to have that whole firm approach where everyone had to do the same thing. But as things are going down the line, and the more that I'm seeing is actually these forms, you've got someone in the employment team being asked about source of funds and it's got nothing to do with them, but they're being told that they have to fill that part of the form out. So I think going forward, and look into the future, having more bespoke risk assessments is probably going to be really useful for them, because there's just becoming so much friction between, compliance and some of the teams, especially the unregulated teams, because they know that they don't have to do this. And it's causing them issues because, like you said, Amy, you have to open matters up sometimes. Sometimes the work is so important, say in litigation or employment, that they've done the work before they've even managed to find time to get the ID. And then actually the ID takes longer to get than the work itself. And there just seems to be like this vicious circle going around.
Yep. So coming back to then what we're talking about next, this bit here, which is it was a really good question from Kate, because once you've done like the pure, what you might call pure AML, like the broader regulated risk and matter risk, how you approach that as a practice and how you do that. I mean, we're definitely out of SRA template territory now. We're now into that discrete bit of, for example, Amy, perhaps like, I know we were talking, again, we talk a lot about risk and client intermediary. One of the things is that could just be a tick box. But what does that mean to you, Amy? It might not be that on every transaction you see that. And we're not talking about an estate agent, but how does that, how would you manage that?
We don't come across a huge amount of intermediaries, but funny enough, I met one for the first time yesterday, and it does then start to flag more questions. You think, oh, okay, well, how do we deal with this? And it would probably just be how we would deal with a normal third party, like an attorney, for example, but making sure that people know they need to flag that and asking the right questions. Collating all that information together and putting it all on a risk assessment form is quite difficult. So
it's muscle memory, isn't it, of like ticking a box. We were running through a risk assessment in Foresight yesterday, and it was really interesting. It's like, you know what, I actually have to think about intermediary in a different way maybe than I did, because your muscle memory is to tick the top left no, or to tick the box of no. And when I say tick, I know everyone on the webinar is probably thinking, Jane, we don't all use paper forms, we're not all dinosaurs. But it doesn't matter what you're putting in. If you're putting it into a case management workflow or any other kind of workflow, if it's your input driving it, then how do we know what you're putting in there for intermediary is right? So it's that, when I say tick boxes, I know you're not all using paper. And Kate, for you, on that, is there any particular part? I know we were talking about when you were talking about attorneys as well, and like how you can rely on what they're providing for you. That's something that you come across?
Yeah, as I said this morning, I was rewriting our policy on it, only because we did have someone that we felt was not acting in the best interest of the client. Now, that's a huge risk.
Huge.
But does the CMRA cover that? No, it's just something that's popped up. And I think it's training staff to realise that risk continues throughout the lifespan of the matter, and not just get that form done, get the file opened, and happy days, you can start working.
So what I'd urge law firms to do there is, I've been seeing quite a bit of this lately, where I'll look at policies that could be huge and really detailed and actually really comprehensive, but then there's a client and matter risk assessment that is how actual risk is practiced. And those policies that say what you do and might have a really great section on litigation that says what risks could be. You know, you come into a litigation case closer to trial, there's a Part 36 offer. I see all of this. It's nowhere near the risk that's practiced. So I think that's really, for us, we have to unlock ourselves from what is a traditional client matter risk assessment, and then decide for your litigation team, what does the client and matter risk assessment look like? For a res prop team, what does it look like? And for a family, wills and probate, mergers, acquisitions, what does that look like? Kaylee, for you, anything that's standing out there for you on the, we've thrown some stuff on here just to get people thinking about the client and matter risk assessment more broadly.
Yeah. So the client instructions being realistic or commercially viable for this matter, I think that's quite an important one as well. When looking at, the risks that could be involved, like you could end up with a complaint, you could end up with a claim, if there's something that, they think that you've said that you can do and actually you can't. So it's managing client expectations, I think, as well. Making the fee earners think like, oh, actually they're asking me this and it's not quite right, but I'll tell them later that they can't do that. And it could be just giving them that bit of a trigger to be like, oh no, we probably should be discussing this sooner rather than later. And I always remember, I've always been really heavily AML focused. So I would go off when, in my consulting role, and I would draw up all of these lovely risk assessment forms before we had all the great technology that's out there now. And I remember I used to work with someone called Balker Baines, and he always used to say to me, don't forget the regulated risk. You need to make sure that it's in there. Conflicts of interest, that's really important as well. Have you carried out a conflict of interest? How do you know that this is okay to go ahead? Having that within the form as well is really, really important.
One of the, what I think like this is the biggest area for everybody, like you say, is using some kind of confidence level. They may not know the confidence level, but they're using some technology for identity, for sanctions and PEPs. But I think on the matter side, understanding what you know about your client at the beginning and how that influences your decision to act on risk is really important. It's always interesting to me, the real basic stuff like judgments or financial profile. I'm a lawyer. All lawyers, like, generally, and tell me if you're on the call and you disagree with this, hate dealing with adverse media because it's media. And I would say, like, it's very different, if Jane left her dog outside the pub in Cheltenham, or she has been, is a party in an inquiry investigating some fraud. Very different to us as a practice. Are we bothered about dogs being left outside of pubs? Are we bothered about the fraud? Depends on how we're acting and why. Not all media is just black and white about adverse media. It's reputational risk as well. So again, it's like some guidance about what you say your appetite and behavior is as a practice and how that is guided through. Also, when people say this to me, I'm always like, but your criminal department will probably, no matter who they are, have a different approach to that than your family team, than your conveyancing team, because the reputational risk or the adverse media risk is different. So again, it's that discrete element, isn't it, across your matters and who you are as a business. And I'm sure, Kate and Amy, your views might be different on it depending on what your work profile is.
I think adverse media is a very difficult one because you are making a judgment call, perhaps yourself, which is entirely different to maybe even the fee earners or anything else. So you have to take I think that's probably why it comes to the professional standards team in adverse media, is we have to take an objective view on it. And
understanding what that is, making sure it comes to you, because results can be buried in a result from a search provider. And you could be like, nah, it's not something that I'm worried about. So having that pulled out and said, this is a drugs case. Is it something that is a concern for you based on your policy? Is really important. You don't want to necessarily hear about that if you're acting for them in defence in the criminal proceedings, because of course you're going to act because that's what you're there to do as the lawyer. So it's proportionate. I think the next point of conversation, which is kind of the full circle on this now, is how we bring all this together. So the reason I've asked us to have a little think about this and talk about it in the market is because your firm-wide risk assessment very often, and this is again a passion project for me at the moment, when I see a firm-wide risk assessment and it is binary and says this department is this risk and this department is that risk, and I'm sure Kaylee's been in, and all the consultants on the call and in the market have been out helping law firms or the teams themselves. work out what that risk is, it's nearly always a point in time risk. So maybe on the 12 months ago, that was what our risk profile was, but what is it today? So if really what's happening is, what I see a lot of is that law firms take a top-down view. So they say, this is our risk, and that's how we manage that practice, because it's somewhere between medium and high. Sometimes I see somewhere between low and high, and sometimes I see, a variety of that. And it's really interesting. But once you've put associated a risk to that, then you come back the next year. But how do you, as a living and breathing firm-wide risk assessment, know that throughout your year, and with what you're doing, your data on your risk assessment is influencing and driving what you've got as your risk for your clients, for your matter, for your departments? How that is, to me, like really, really core, the third kind of part of Complete Guide to Risk Assessments, that we need to make sure that we connect risk assessment decisions that are happening every day across Lawfront, for example, and Lucas and Willis, to what that firm-wide risk profile happens, so that it's not a rush and it's not disconnected from how you manage your risk. I'll shut up now. Amy, for you, how do you feel about that? How does that work for you? And what kind of challenge is it for you to get all that together at the moment?
It is a challenge because it can be quite disjointed, because you've got me with a couple of hats on, and you've got each department head with their different hats on, and getting everyone together and getting the right information out of them can be quite difficult. I suppose it's much easier for us as a firm because we are quite a small firm, and as a management board we meet every couple of weeks, so I'll always be able to keep an ear out for anything that might ring alarm bells. But it is a huge challenge for firms, and I can see why it is done from the top down, because I think, well, I don't know how else to do this. How do you collect the information? How do you keep on top of it? Exactly. But you're right. I'm looking at a list we've got of things that are generally considered high risk and generally considered medium risk. But when you do the actual risk assessment, it probably isn't going to come out as high risk because of X, Y, and Z and all these different factors. And keeping an eye and keeping a control on those is very difficult, and it is a huge challenge. And really, you could be updating your firm-wide risk assessment weekly because things change so quickly.
What about you? What about you, Kate? Because you've got that umbrella organisation piece on the top.
Yeah, I mean, at the moment, it's one of the processes we're going through. We're looking at each firm's firm-wide risk assessment, see where we currently align, see where we differ, and how can we reach an alignment. But you're right, it's being driven by top down. And
Kaylee, your challenge with that, and we talk about this quite a bit, is that the way that law firms have negotiated that, which is understandable, by the way, is like the kind of, I call it the enhanced due diligence trap of like, making sure that to leverage that, a whole practice area might have the same type of enhanced due diligence applied, which is quite, which is not proportionate for the matters.
Yeah, it's really tricky. I think, I see a lot of risk assessments that say that, property work is high risk. And then they say if the client or the matter is high risk, then the whole thing is high risk. So you might have like quite a low risk client, but actually a high risk work type, but that needs to be high risk. And then actually when I look into it, so it says you have to do enhanced due diligence if it's high risk. And then I look at the file and I'm like, well, actually the level of due diligence that was carried out, I feel like was sufficient. But because your risk assessment has said it's high risk, you should have, applied enhanced due diligence. And then what does enhanced due diligence actually mean? What should they be getting for enhanced due diligence? That's different to what they're already doing, because a lot of firms as well, they probably pretty much already apply enhanced due diligence to everything. And then it's really difficult for them to say, oh, we did this differently to make it, more enhanced. So I see things like, we'll get an extra proof of address. I'm like, how is an extra proof of address going to help, mitigate the risks of money laundering in this matter? So they're just trying to let's just get extra documents and it might help. And, that's not what this is for. This is not what it's meant to be helping. So I think there's like that difficulty as well, understanding like why are we doing what is the purpose of what we're doing, and why are we doing what we're doing. I think that's forgotten sometimes, and it becomes very procedural rather than that thought process of how are we going to mitigate the risks of money laundering.
I think if you pick up the challenge for most law firms is, if no matter what technology they're using, if they pick up their current client matter risk assessment and don't transform that, if they just pick it up and exactly the same way put it into some kind of digital platform, it's going to give them exactly the same results as it did before. So for me, one of the things that I always think is really crazy about the SRA's risk assessment is they tell you do all this, and if it is, treat it as enhanced risk, and then do the following. So most firms are like, well, I have to do enhanced because I can't check all of this has been done. But for me, like with technology, if you can follow what the actual risk is. So let's look at Amy Church. She's a new client coming into our practice. She's an individual or a business. What does her risk look like? And then build that risk for her. And then the same for the type of transaction. Instead of waiting to ask a question in a risk assessment that's only asked enhanced due diligence level, those questions are part of how you build up organically the profile of Amy's risk. Now, I know that's pretty disruptive, but like it makes the job easier because you're relying on looking at who Amy is, so that when Kate has to look at Amy, she says, well, I can look at the bigger picture of Amy, in regards to who she is. And then when I'm looking at media, for example, it is proportionate because I understand more about Amy as a person and as her matter, rather than just, going through and saying, I haven't looked at it because it wasn't enhanced due diligence, or I've looked at things which I didn't need to do because everything's enhanced due diligence. So I think it is like, I always refer to it as like a Heston Blumenthal when you've got like you're deconstructing your food. You do the same with your risk assessments. You take it back to basics and build them up ingredient by ingredient rather than slotting it all together. I think we've never had, there is a real incredible opportunity in 2026 for law firms to leverage technology that does that. I don't think if you've done it, I come across incredibly robust client matter risk processes, firm-wide risk assessment processes, firms who spent a lot of money in a piece of technology that does things very linear and loads of conditional logic, but it doesn't work anymore. And the problem is pulling that apart with, it's hard. So it's almost easier just to flip it on its head and say, how would I do this incrementally? How do I look at Amy step by step? And then how do I build her matter risk on top of that? That is that would be the way that I would probably look at that.
I completely agree. And I think that kind of comes back to a question I had the other day, clients like Fiona saying, I've had this client, they don't want any searches, they don't want a survey, they don't want me to ask any inquiries, they just want to get on with it. But they're a builder. They're doing this a lot. Builders we know generally on that in a hurry. They want to get it done. They want to get the deal done. They want to build the house. They want to crack on. If that question had come from somebody, I don't know, you had a barbershop in town, you would be flagging it as this could be a problem. So you're right, you need to build it up depending on who you're dealing with, not just the blanket. If someone says they don't want to search for survey inquiries, they are high risk or there's an issue here. So just looking at it in the layers.
I was sitting with a head of resi in a firm up north and watching her use Foresight, and it asked her a question. We were talking about trying to work out the profile made sense, and we're like, what does your client actually do? Because it says he does this, but it doesn't probably make sense based on what the earnings are. And we were like, what does he do? Where can we find that in all the data? Because we haven't actually entered that in. We haven't got that in a way that made sense from the beginning. So how have we triangulated that? So it's just, again, like, does it make sense? I was looking at his photo going, he looks a bit like is he a plumber, or is he actually a CEO? Is he actually a CEO of this technology plumber? What does he do? It's quite a fun game, and work out what your client does from their photo on their digital ID. I recommend that to everybody. Okay, Kaylee, anything else to add to that?
Yeah, I just think for the firm-wide risk assessment, people have gotten their heads, the SRA are asking for more granular detail within the firm-wide risk assessment. So people are throwing all of that granular data in there, but they don't actually understand why they're putting that data in there to help them assess the risks. So I see lots of information in there and I'm like, but yeah, this means that you're not as risky as some other firms. So, yes, we've got a conveyancing team, but actually it's a really small proportion of the work that we actually do. The rest of the work is all regulated. So it's making sure that you're gathering that data and you're actually really understanding that. A firm that does conveyancing and has had no suspicious activity reports or even internal ones sent them within a year period, I'm probably going to say, like, you might have a training issue here if people aren't coming to you, because 100%. There's bound to have been some matters that have come through that have raised a few eyebrows. So it's also making sure that the data that is being collected is actually being looked at and reviewed in the in a way that you're reviewing the risk. rather than just putting it in there because the SRA's asked for it. The SRA's asked how many PEPs do we have. I mean, and I break it down into domestic PEPs and non-domestic PEPs, because obviously domestic PEPs are less risky apparently than non-domestic PEPs. You know, so it's just breaking that down and, you know, really understand why you're putting that data in there. How is it helping you assess the risks of your firm?
One thing that I learned quite early on in the product journey and risk assessments was that what happens in the market, obviously it's really important to escalate, and you should, based on the risk, be able to automatically escalate that to who you want that to be. And that's a given. So for us in Foresight, that's a given, understanding not just top level risk, but any meta level of risk that's relevant that you as a firm choose for that matter or client type. It's really important. Red flags, come on, there isn't a list. There isn't a definitive list. So you as a law firm, Kate and Amy may choose that some of the risks we've been talking about are different for them and that they want to know about it to pause the practice, Kate. So that way you could say, carry on. And that gives more agency to people to understand that risk assessment. But the bit that I found that was really interesting that we acted on was that people want to talk about their risk. So at the moment, if you escalate it, it's like you're fessing up to either you don't know what to do, or you're throwing something that the MLO is going to kill you because all you're doing is throwing it to the compliance team. And the compliance team have got 50,000 questions in their inbox about sanctions. In a larger law firm that we've seen, or in mid-sized law firms, asking the same questions because they just want someone else to answer it for them. So this idea of collaborating on risk and being able to talk to your peers about it, so you don't have to go to Kate, because if you go to Kate and she's like, for God's sake, you know, it is just leaving a dog outside the pub. Or with Amy to say, I'm so glad you asked me that question because it's the right question. But it isn't like I'm not on like the naughty step for asking questions and enabling people to learn. I don't know, Amy, and you know, for you it must be easier because people might feel they can just pick up the phone or do that to you.
Yeah, I do get a lot of questions on a wide range of issues. Some things where you think, okay, well, that might seem like common sense, but they're clearly questioning it for a reason. So, yeah, people do often send me, I've got a few in my inbox today, just little things. Actually, I'm glad of that. And I do encourage it because it shows that they're not scared to ask. They are looking at the information. They're not just ticking boxes. They're trying to understand and get to the crux of, you know, what is the problem here. So, and often it is a case of working together. Okay, well, you've got this. Why don't you go back and get this? And can we check that? And then you come back to them when you've got that, just as a kind of collaborative approach to it, just to give people the confidence. And often once you've done that once, they'll think, oh, okay, last time we did this, we'll go back and ask those questions before we come to Amy and present her with that information. And I see that, and it's nice to see the team learn. So
it can probably be unmanageable though, Kate, I imagine. I know I hear from the larger size of the legal market that, you know, when they've got big teams of analysts, and for them they are looking at that and also working on how they know what they know and what they learn about that is quite important. So for me, again, from a product perspective, it's really important that risk isn't just about actually completing the risk assessment and the firm-wide risk assessment, and it's all data driven, but then it's what you learn about that. And Kate, how do you, because for you, again, I keep coming to you, but you know, when you've got that across the different practices,
I mean, we have it plastered absolutely everywhere. Our group email address, so that if in doubt, just email us. We don't care. Yes, we're inundated, but I'd rather find one thing that may put us all at risk in amongst all that. So it is your inbox. You just think, I'm never going to get to the end of this. But at some point you will come across something that you think, thank goodness they sent me that.
So I think, again, just like the how we can, making sure that we open it up so that we have that conversation. And then the next stage of that is, how can technology help you learn from that? So how can you learn from that? You know, we talk to people in the market as well about plugging into our data for training so that they can understand, because we have so much information about law firms, so that we actually understand what it is that you are doing and that you could do differently, and what the gaps might be. Should we, Arslan, I just wonder whether we've got like 3 points on the screen of everything we've talked about just now, really. Are there any questions, Arslan, that we should be answering?
There's some good questions. Brian has asked some great questions. Do you want to cover this, or do you want to get right into the questions? Or
yeah, no, just get straight to questions, I think. Yeah.
Cool. Let me go to the first one. Brian, we're just having some issues. We can't click on the question to make it appear, but Brian Rogers asks, Why do so many CQS Lexel firms get fined for AML procedural breaches? Any thoughts?
I have thoughts. I'll go to Kaylee first, because I think Amy is going to be like got angry, maybe. Or Amy, let's go to Kaylee first, and then we can take that up.
Yeah, I think it's because they think that they're CQS, so they have certain training, they have certain requirements. The same with Lexel as well, and they think, well, we've passed Lexel and we've passed CQS. That actually they think that that's sufficient in what they're doing. Lexel is there, that there's just a question on Lexel, as far as I'm aware, that just says, have you got policies and procedures for your AML? And they tick a box to say, yes, you have. But I think there's some sort of misconception that because they are accredited in that way, that they must be okay. And that's not actually the case.
Amy, you were nodding. Does that feel right to you as well?
Yeah, it does. I think a lot of people get a bit complacent in that they haven't actually, like I say, you could download a policy from the internet, you could get ChatGPT to do it for you, but are you actually checking that it covers the right bases? Is it being completed in practice? You know, people are busy. You know, everyone's busy. They don't like these red tape boxes. Are they actually filling it out? And I think that's where a lot of the fines come from. People have got the policies in place, but there's no evidence they're actually being completed and done in practice. So it's just how you join that up and make sure people are doing them properly. I think a lot of it does come down to understanding. You know, we keep talking about how complex it is. People don't understand. They've got this paper. Well, what am I actually doing with this? How do I use this properly?
I mean, I kind of flip it the other way around as well and say, obviously, from an SRA perspective, they're easy targets because your CQS and potentially Lexel as well, you know, you are doing what they would perceive to be, you know, high risk of money laundering. So they're going to come and look at those cases to look at whether you understand source of wealth and source of funds. So SRA themselves are more likely, I would say as well, Kaylee, do you think, to go into those firms because they're the ones where, especially if they're doing particularly reviews of them, of something like a source of funds review we had recently, didn't we? That if they go in and do 10 of those firms, they're more likely to see the practice on some really high risk transactions that could be high risk than if they were doing them on firms that weren't CQS just by the nature of the work.
Yeah, I don't think they would admit that they do that. I think they say that, you know, they're just trying to visit all firms, and they do potentially pick higher risk firms anyway. So the fact that they just do property work would probably be a reason why they've been picked. It's quite an interesting question because you know, as an accreditation for CQS or Lexel, it's got nothing to do with the money laundering regulations. So I'm following the money laundering regulations. So
and it's interesting for me because I was CQS and Lexel when I was in practice, and I was talking about this on Bricks and Banter podcast with Tom Parkinson and Laura Cartwright, and that we were saying that, you know, I used to love a Lexel audit because it was an opportunity for me to show how we managed risk across our clients and matters. Not necessarily AML, but I believe that, you know, it's an opportunity for you to have really great process and procedures in place. Within case, lots of firms do that within case management, but it's the same point that Amy said. Really, if you tick boxes in doing it, Kate, I don't know if that's your view as well, Kate, because you will have all of those accreditations as well.
We love audits. We do.
You do. You're in my.
I mean, about to have a Section 21 audit that'll go on for a week because you think you're doing a really good job. You're following everything that you read. You're constantly reading the SRA. I'm constantly reading LSAG. You know, you name it, I'm reading it.
Yeah.
Have I actually put that in practice properly? Does it work? I like to think it does. But again, an audit will tell me.
So a couple of sides to that, I think. Maybe a bit of complacency, maybe the specific focus on it, and maybe like those firms really, you know, have got those practices and procedures, but not changing for a long time. Or like Kate says, auditing themselves, it becomes quite complex. Arslan, do we have other questions? We'll wait for him. We've lost Arslan now. We've put him off. We've put him off by asking those questions. We can have a quick look and see in the chat.
They're not coming up for me.
Oh, how annoying. Sorry. If anyone has got any other questions and they just want to put it into the chat,
Sorry, by the way, I didn't know you couldn't hear me.
Okay.
I was talking. Yeah, Brian asks a few good questions. He followed up with another one. He said, what should be regarded as a high-ranking military officer in the UK for PEP purposes? There's nothing in the money laundering regulations to say, but there is in the LSAG guidance 3-star level. However, it is interesting to have heard from my military and AML connections who say it shouldn't be based on rank, but rather the job they did as some lower ranking officer may be regarded as a PEP. Any thoughts?
Yeah, interesting one. Kaylee, do you want to come in? But I think what basically, she's nodding her head, she's shaking her head. So basically, I think what he said there is really important. So yes, I mean, it's like when we talk about PEPs and we talk about like domestic or non-domestic, it's quite binary. And we think because we might know David Cameron more than we know a political figure from a different country, we can maybe assess that risk differently. But I would also say in regards to when you're thinking about what that person has done for their job as opposed to their title, it's a really good example of making generalizations. So if you make a generalization of what someone's title is on risk without actually looking what they've done for the purpose of that, then it's exactly the same whether it's military or not. I'm sure we can get Kaylee to come back and give you a response on that separately, but my view would be it's looking at that specific. If you always say this particular rank for the PEP and you categorize it that way, you're going to get yourself into difficulty probably.
Yeah, you need to be really careful. You need to be making sure that if they need to fall within the definition of a PEP for you to classify them as a PEP. There's nothing to say that you can't say that this is outside of our risk appetite. So we're going to, add enhanced due diligence to this matter. That's absolutely fine. But you've got to be careful actually calling them a politically exposed person. There's been lots out in the from the FCA, they changed the definition of a PEP at the beginning of last year for that reason. So I think it's just really important that, they might not be generally that they might not fall within the definition of a PEP, but we still want to classify them as high risk because of the job that they do or because it falls outside of our risk appetite. Just don't call them a PEP if they're not a PEP.
Yeah, it's kind of
I do. Sorry, what I was going to say is
no.
I do live in a military town.
Great.
So we have this. So no, we don't necessarily identify them as a PEP, but we have something in place depending on their rank and more importantly, the role they undertake.
It's the role, isn't it?
It's the role that they have in the military that determines whether or not we class them as on the same level as a PEP, but without calling them a PEP.
Yeah. Cool. Arslan, anything else?
We can't hear you.
We can't hear you again. Sorry, Arslan.
Sorry about that. It's technical difficulties. We do have a few comments, but out of interest for time, I think we should cover the last few points on the slides. And then if there is a little bit more time and people leave a good question, we can answer it. So Jane, let's go back to this slide and have you.
Yeah, so I think just like summing up, everything we've talked about today comes back to the beginning of start with a client and matter risk assessment that makes sense for your practice. I think we all agree here that the SRA out of the box one doesn't for most practices. And that if you are using that, it doesn't mean that your risk isn't going, your risk practice is defective, but it does mean that the first starting point for a smart risk assessment is to make sure that it is bespoke for you. And that really does mean probably rethinking what that is, and you can get some help from any of us on the call on that. You can speak to me, you can speak to Kaylee after the event on how you'd start that if you don't have that. Your dynamic workflows on here. So again, matter and regulated risk. Dynamic workflows. I'm not using workflow as in a case management term of workflow. We do this and then we do this next. But I am talking about understanding that your client and matter risk assessment and what you think about and what you ask your team about when they're completing risk is different depending on whether you're dealing with unregulated work and the type of work, the type of client and the type of matter. So if at the moment it isn't, that is a big win, I think, for law firms. And then the final point on ensuring that your client and matter risk assessment feeds your firm-wide risk assessment, and that your firm-wide risk assessment, dare I say it, even on an annual basis is probably not enough. Understanding the data that you have and how that is connecting into the actions that you're taking every day so that you are proactively reviewing your risk rather than reactively every year reassessing it is what I've seen from the work that we've done with Foresight is a big win for clients, that they know every day of the week what that looks like, as opposed to, and how that evolves. You might then want to be able to take on different matter types or adjust that risk and then record what you've done with that as your year goes on. So that was kind of my the kind of 3 points, Arcelin, coming back to that. Kate, Amy, Kaylee, anything? I'll come to you one at a time for closing. Amy, anything you want to add to that? On your journey, maybe which bit of that you're on that you're next for, or?
Well, next for us is particularly for, I say conveyancing, as it is the higher risk area. The higher risk areas, I think, will be enhancing our risk assessments, particularly using Foresight with how it all pulls together. You've got all this information, but how does it all slot in together? What is the actual risk, rather than just ticking boxes, and using it as like a live decision maker, really. That's our next focus.
Kate?
Our next focus is aligning the risk policies across the group to feed into the CMRA better, because
so important
at the moment it does in each firm to a level, but it has to be more against the policies. At the end of the day, which fee earners reads your 30, 40 policies?
Tracy and I say what you do, and Kaylee, and then do what you say. So you can't do what you say if you don't say what you do. So you're in the say what you do bit right now, making sure that makes sense. And Kaylee, from your side, what do you think of those three? Anything else you just wanted to add on the three?
No, I don't think so. I think I do feel like there's, like you said, that needs to feed into your policies. So I've seen a lot of processes happening, but I've read their processes. I've actually read their policies and it's not in there. So it can make it quite tricky for, lawyers to follow a process if it's only in someone's head rather than actually being written down somewhere. So I think just make sure whatever you are doing on the ground, make sure that, if it's working, make sure it's written in your policy so anyone coming in would be able to understand what your process is.
Amazing. So we've run out of time. I really love talking to you guys about it. Thank you, Arcelin, for facilitating this. We'll put a slide where you can contact me. You'll be able to contact Kaylee. Obviously, we're on LinkedIn. We're doing this on LinkedIn. So if you want to connect with Amy, with Kate, with myself, or Kaylee, we're happy to talk about anything that we've touched on today or bits we haven't done. Give us ideas for what we can do next time. And hopefully it's been insightful. So thank you very much. Thank you, Amy. Thank you, Kate. Thank you, Kaylee.
Bye.
Bye. Okay. Bye.
Bye.